if, oh, there it goes. I got a notice. Leave meeting, got it. So at any rate, if you compare the Georgia Constitution, especially its Article 1, Section 1, with other states' constitutions involving juries, you're going to find the state of Georgia is unique. Of course, now the state of Hawaii is unique also, but we'll get into that later. Let's see, we've got a couple of questions. Ms. Alexander, I guess it is. You want to unmute and give us your question or your observation?
Charlene, is your hand still up or is that just from
I need
before?
to take it down. You already addressed it, Judge. Thank you.
Oh, okay. And Ms. Collier? You want to unmute and give us your question?
Yes, sir. Did I do it?
Yeah, your hand's still up.
Well, darn.
Well,
Okay.
we can hear you now. What's your
Okay,
question?
very good.
Okay. So do you have a question or a comment?
Oh, I was just looking through your assigned reading, and it seems to me that the Constitution is not being followed at all.
Oh, no, heck. No. Surely you jest, young lady.
Oh, no. I mean, I know better. I've been watching it for 2 years now.
Okay. All
I
right.
don't know. I guess the question is, what the heck do we do about it?
Well, that's something you're going to learn here.
Okay, good.
To start off this lecture, I suppose it's prudent for everyone here to understand that our Constitution came to us because of a contract. And fortunately, that contract has been validated time and again by our Georgia legislature and by the vote of the people. Now, what the original contract did was it told the legislators at that time, at that early date, that they needed to enter into an agreement with the other states and create a charter. And that charter would be to serve the purpose of establishing a nationwide method of governance. Now, the state of Georgia also entered into the citizens of the state of Georgia entered into a contract with one another, and they established our first constitution in 1777. The Constitution has evolved into its present state. But for all of the glorious verbiage that can be used to describe both our state and our federal constitution, it is important to understand that they are nothing more or less than charters which have established a mode of governance for the people. Now, one of the unique things about Georgia's constitution, unlike the federal constitution, the Georgia Constitution has evolved so that the charter under which our government functions, when those folks go to check the Constitution, the very first thing they find is the rights, privileges, and immunities that are specifically reserved to the people. And those are not to be transgressed unless, of course, there is an abuse. Now, one of the problems that people have sometimes in understanding their rights, privileges, and immunities is that they can abuse them. And when they do abuse them, there is, at that point, there is that time when your right can be subjected to another authority, the authority of the state, for example. So just because you have a right of speech doesn't mean that you can go say anything you want to. There is a limit. The press also has a limit. And if we can ever get our foot to a grand jury in this state, they're going to find out what that limit is. But just keep in mind that you know, excuse me, I just remembered I had something I needed to post in the chat, and I haven't even got the chat screen. Y'all are moving too fast for me. You know, let's see, where was that? Well, I'm just going to have to keep talking, I guess, and look for it later. Oh, wait a minute. I know how to do this. I know how to do this. Let's see. Let me go here. Come on, come on, come on. And well, I shouldn't have done that. Okay, I can do it this way. And I better go do it this way.
is it something I can help with, Judge?
I've just got to copy a link here.
Okay.
I want to post. Copy. Now let me see if I can paste it. There we go. There we go. Now there is a link that you can copy and put on your favorites bar. And that will take you to both the Georgia code, and another link will appear on that first page where you can go to your Constitution, Georgia Constitution. And if any of you want to try it out, you know, you can just go ahead and paste it on your browser. And then in the upper right-hand corner, you can find the link to the Georgia Constitution, and you can click on that. Now, one of the things that will happen is when you select some provision that you'd like to go to, then the first thing that's going to pop up is you've got to prove that you're not a robot. I don't know why they would have that function, but if you were to go, for example, to Article 1, Section 1, and click on it, then this CHAPTCHA screen pops up, and you got to click on that. You may or you may not get a graphic that'll have to be taken care of before it brings up. But after that one time, the rest of the time that you use this link, then you won't have that CHAPTCHA graphic to have to fool with. But one of the nice things about this is, and this, by the way, is thanks to your Georgia legislature for arranging this. not only do you have access to the language of your various constitutional provisions, but if you scroll down, you will find that there's an awful lot in most of these statutes. There's an awful lot of case law underneath that. And case law is very useful in helping you understand the limits, whatever those limits might be. And it can help you understand an expanded understanding of just how far the reach of that constitutional provision can be. Now, in our Article 1, Section 1, oops, I forgot. Article 1, and that's all 4 provisions. Those are the rights, privileges, and immunities. And all of that is protected from, supposed to be protected from abridgment by your government or the federal government. And as you can see, if you're looking at those, you can see that we now have 30 separate provisions under our Article 1, Section 1. And this gives this is an opportune time to show you a little something about Article 1, Section 1, paragraph 29. Paragraph 29, which is labeled enumeration of rights, not denial of others. That the shortened reference to that is the prior rights provision. And since we're on that, let's talk about Georgia's legislature and the Atlanta Journal-Constitution's big spreads, headline news about the state of Georgia repealing the right of citizens arrest, which used to be under 17-7-60. I hate to break it to you folks, but your right of citizens arrest still exists. There is a provision, another provision in Title 17, 7-30 something. I've forgotten what that is, but it also provides for a citizen to make an arrest. But the reason that your right of citizens arrest has not ceased to exist is simply because that right way back into the common law, it is a prior right, and therefore it is still protected under Article 1, Section 1, paragraph 29. Another reason it is protected is because in contract law, there is innumerable case law references to the fact that if you have a right that is expressed in the contract, in order for that right to cease being executable, there must be what is known as specific repealer. In other words, a new written contract will have to contain language that the prior right of citizen's arrest is no longer valid or executable. Well, it just so happens that all your state legislature did when it came to Official Code of Georgia, section 17-7-60. All they did was rewrite the language and left out that part about citizen's arrest. That is not specific of repealer. A right cannot be eliminated simply by leaving it out or changing the language. There must be language that says that specific right no longer exists. Just because the state legislators went out in front of the Atlanta Journal-Constitution or Channel 2 or Channel 5 and said, yeah, we're repealing citizen's arrest. They didn't do it. There is no language in the article, in the act of the legislature, which says that the citizens can no longer exercise their right of citizen's arrest. Specific repealer did not happen. So just so you know how some of your state legislators can be expected to be craftily, artfully deceptive. This is a good example. And I hate to say it about a bunch of legislators, but bless their hearts, them and lawyers, and most of them were lawyers, apparently go to school to do nothing but learn how to be artful deceivers. Oh boy. I'm sorry, I apologize for that. So anyway, now.
Judge Nally, may I ask a question?
Yes, sir. Fire, y'all ask a question anytime. Jump in.
Would removing our right to citizen's arrest actually require a constitutional amendment?
It would require a specific repealer in the language of the act changing 17-7-60. Let me think just a minute. You've just raised a question that's never occurred to me. You know, it could be included as a separate sentence in Article 1, Section 1, Paragraph 29 that would specifically state that citizen's arrest, the prior right of citizen's arrest stands repealed and no longer enforceable. So yeah, it could require, I mean, it would not require a change in the language of our Constitution, but it certainly requires the language of specific repealer as applies to that code section. Does that help answer your question? I guess I must have put Ted to sleep. But
So in accord to what you were saying, that it's from our common law, what you're saying is all they need to do is add a little repealant in there and say, hey, that's no longer part of your common law? Because I find that hard to believe.
No, it's not common law. They don't have to refer to it from its common law origin. All they have to do is say in words to this effect: the prior right of citizens to perfect citizens' arrests is no longer a valid right and may not be exercised by the people. That's basically the language that would have to be used. But that language does not exist in that enabling legislation. The act of the legislature did not put that language in there.
Excuse me. I
Yes.
was under the impression that there was no law that could be made that goes against our rights. I don't have, I'm not prepared as far
Well-
as I'm not organized to be able to track it down written, but that was my understanding, that there can be no law written that it's null and void on its
Yeah,
face.
that is a basic correct understanding. A law cannot be made at any time, or should not be made, which contradicts the Constitution.
Okay.
Every time I can remember the times when Barry Loudermilk used to talk about his service down in the legislature. And he always kept either in his pocket or in his desk drawer a copy of the Georgia Constitution. And he used to laugh about that some of the representatives on the floor, when there was a bill that had a question about its constitutionality, they'd always say, well, let's go over here and check with Representative Loudermilk's copy of the Constitution and see if we're doing this the right way. But
Did he have a pocket of the Georgia or the federal?
the Georgia, he kept a copy of the Georgia Constitution in his pocket. But whatever in order for there to be a statute that says a citizen cannot perfect a citizen's arrest or any other deprivation of a right, privilege, or immunity, the Constitution itself would have to be changed, permitting the legislature to do such a thing. And I don't see that anywhere
Amen.
in this Constitution.
Yes, amen.
Excuse me, Judge Nally.
Yes,
This is Lori Wood. My question is, though, is that when I was researching this the other day, is that, back in 2021, when Kemp was trying to get this citizens arrest law changed, and they were trying to push it into a House bill, I think it was 460. Can they do something like that where they would put the repealer in one of the House bills? With
that's exactly where it has to be.
okay,
And if you'll go back and read the bill, all the bill does is changes the language of the statute 17-7-60. That's all it does.
okay, great, thank you.
And there is no legislative intent. But that's the reason why there's no legislative intent, is because of Article 1, Section 1, Paragraph 29. The legislators knew we cannot do a specific repealer. I mean, we have to do a specific repealer if we are going to get around Article 1, Section 1, Paragraph 29. And they didn't want to go that far. So what they did is, rather than specifically repealing the right of citizens arrest, what they did is they just changed the verbiage of the statute. And then they went out and told everybody, and the Atlanta Journal-Constitution and everybody else, every other newspaper tells the world, oh, there's no longer citizens arrest in the state of Georgia. They've repealed it. No, they didn't. Your newspapers lied to you. Your legislators lied to you. And the reason they did is because They don't want you being able to arrest them.
Yeah.
And the reason that, and there's a very good reason why they don't, and that's this. For those of you who are interested in how statutes relate to constitutional provisions, the Supreme Court of the state of Georgia, and I think this was back in the 50s or 60s, made a determination that for a citizen's arrest to be effective, only 3 words had to be spoken. You're under arrest. You did not have to touch anybody. You don't have to put them in handcuffs. Just say those 3 words. You're under arrest. And that is a legal arrest under case law precedent. Now, the question is, well, was it a lawful arrest? Well, guess what? There is a provision, I think it's also in Title 17. It's either 17 or 24, that says that the lawfulness of an arrest is always a question for a jury. So, you know, if you tell somebody they're under arrest, they're under arrest. And of course, now there's other duties involved. For example, you have to take that individual under the Georgia and the federal Constitution. You have to take that individual immediately to a committing magistrate. Now, immediately does not mean 72 hours. And I'm quite sure that a lot of you have seen or heard of some of your neighbors or people they know being taken to jail and being held for 72 hours and then taken down to see a judge. That's not the law. That is a violation of the Constitution. Arrest without a warrant requires the immediate appearance before a committing magistrate, and I don't care if it's 2 o'clock in the morning. Get him out, get the judge out of bed. And if you arrest with a warrant, you still have to bring him before a committing magistrate. But the cops don't want to do that because that might not give them time to get their stories quite correct. And it's really sad, but that's the law. And the Supreme Court of the United States, when they made that decision, and I'm trying to remember, Gerstein v. Pugh. Forgive me, I don't have the site, but Gerstein v. Pugh. But the Supreme Court spoke to all 50 states in that decision, and they did it twice. And the essence of what they said was, we don't care what kind of verbiage you use in your laws to take a citizen from a condition of liberty into a condition of custody. We don't care. But you will present that individual immediately before a committing magistrate. Now, there were some subsequent laws that police officers, law enforcement officers, and sheriffs, and lawyers, government lawyers, not defense lawyers won't tell you this, but government lawyers will tell you, oh, there's another case that says we can wait 72 hours. No, there is not. There is no other case that says that it is constitutionally permissible to wait 72 hours. That case doesn't exist. What does exist are a couple of cases where law enforcement officers had taken custody of an individual, headed out to see a judge, and a radio call comes in. All cars, we have armed robbery, we have a shooter, we have an exigent circumstance requiring all officers immediate attention. And so what they did is they went, put the person in jail, then they went to act as backup on that exigent circumstance. And then they came back and did paperwork, whatever, had some donuts and some coffee. And then they decided 72 hours later, well, we'll take this guy down and see the judge. Now, the courts did say that in the event of an exigent circumstance, then 72 hours was not beyond the realm of reason. But no court decision has yet come down that I'm aware of, which says you arrest somebody on the side of the road, you can take him to jail, you can book him in, you can go do your paperwork, you can go have breakfast, maybe some coffee and some more donuts. And 24 or 48 hours later, then you can take him down to see the judge. There's no such order. It doesn't exist. So if they tell you they can hold you for 72 hours, no, they cannot. You must go see a committing magistrate immediately. Of course, that doesn't set too well with the magistrate judges, because bless their hearts, they're the ones who have to get woke up at 2 o'clock in the morning to listen to a defense of why that law enforcement officer should not arrest the detainee. At any rate, I'm sorry, that's probably not the kind of a lesson you wanted to hear today on Georgia's Constitution, but that's where we wind up. Now we can move on. Oh, and by the way, you need to get yourself familiar with all of Article 1, Section 1, just as soon as you possibly can. Likewise, you need to pay attention to the origin and structure of your government in Section 2.
Judge, I have a question.
Sure, fire away.
I have a lot of questions, but so you're saying, because my friend, Dr. Simone Gold, it looks like her rights were violated. But maybe California is different. You can hold people without a lawyer.
No.
Days.
The Supreme Court spoke to all 50 states in that Gerstein v. Pugh. They spoke to all 50 states when they came down with that decision. But excuse me, go ahead.
Oh, so my real question is, so we just go up and say, Raffensperger, you're under arrest. And then we call the judge immediately. But what if he won't come with us?
Well, you of course can go ahead to the magistrate judge and explain to him that you've already placed him under arrest and he refused to accompany you to a commitment hearing.
Okay, and then just see what he says.
So then the judge can issue an arrest warrant based on your sworn statement. However, Be absolutely certain that you have the evidence before you arrest anybody. You've got to be absolutely certain that you have the evidence in your custody and in your control. Because if you don't, they finagle out of it, then they can bring suit for false arrest.
Judge, here, the more I'm thinking about this, the more it's confusing me. I mean, it doesn't seem to be in the court. If you're going to take away the citizen's arrest, then don't you need to get rid of the militia? Now, I know for all intents and purposes, our militia is no more, but that's unconstitutional. So we need to reinstate the militia and teach everybody. But if you're going to take away the citizen's arrest, well, what's the militia going to do when they have to suppress invasions and combat insurrection? What are they going to do? Just twiddle their thumbs?
No, no, they're not going to twiddle their thumbs. And now that you've mentioned that, the militia in the state of Georgia still exists. You have standing army under the federal jurisdiction. You have the National Guard in the state of Georgia. The National Guard is called the organized militia. And then you have the third branch, and that is referred to in federal law as the unorganized militia. And that is comprised of every male individual between the ages of 18 and 45. So all of you young whippersnappers out there, understand that you are subject to call at any time. If the organized militia in the state of Georgia can't handle it, or if it's getting too much for them, then the governor may, oh, I'm glad I said that word. The governor may call up the unorganized militia. Now here's something y'all need to understand. When you are reading statutes and constitutional provisions, you really have to pay attention to the words. May, anytime you see the word may, that is a word of discretion. In other words, whoever that language is directed to may do it, or they may not do it. It depends on the language, but the word may is always a discretionary word. The word shall is, of course, a command word. There is no discretion. And the Supreme Court, where it comes to judicial duties, has come down and said that anytime a statute tells a judge that he should do this, the Supreme Court interprets the word should as shall. Now, that's not something that lawyers and judges would share with you folks, but now you know it.
One footnote here, just for that, it's my understanding that the Georgia militia should have, or does have, an organized and an unorganized militia. Also further, that the Dick Act, bringing in the National Guard to replace the organized militia in each state, is entirely unconstitutional in and of itself. That's a whole other conversation, so I'm going to leave it there. But it's unconstitutionally, it's a constitutional unknown. The National Guard does not match our common law, and the mindset, and we can discuss this at another time because I don't want to take up time, but the mindset of the National Guard and the militia from each state is entirely different, and I yield.
Thank you. Now, in going on, most everything, virtually every provision in the Constitution, Article 1, Section 1, are self-explanatory. I mean, they're easily understood by virtually everybody. The origin and structure of government, just scanning at those, all of these are also easily understood. The one that I would really like to call to your attention, though, is Article 1, Section 2, Paragraph 5. And it's a rather lengthy, well, it's not really that long, but it deals with void acts. But it also deals with a waiver of sovereign immunity. Now, here's where a little history would be probably beneficial. Back when we first opened up this session, I tried to explain to you that the Constitution, in spite of all of the language describing it, is nothing more or less than a corporate charter. And that charter, based on the preamble, which by itself is not law, but it is instructive as to who the chartering individuals were. But in this question of sovereign immunity, the state of Georgia, and there are a lot of cases that have gone on in the last several years where the question of sovereign immunity has been abused. And it has been used to conceal criminal activity. And that's a sad commentary upon us. But sovereign immunity is a question that you can trace all the way back to the Magna Carta, the Great Charter. And in there, in that charter, and I think it was somewhere in the late 50s, and I don't mean years, I mean, I'm talking about clauses in the Magna Carta. But the king made the comment that when it came to one of his subjects' person or one of his subjects' property, if that individual subject was disseized of either his liberty or his property, then the 25 nights, which was the beginning of, I mean, this is the real beginning of the grand jury in that document. But those 25 nights were to take that subject's question of property or liberty to the courts, especially if the king was out of the country. And the courts would make that individual whole. So when it comes to sovereign immunity, we have to keep a very close eye on our state, especially when it comes to being deprived of our property. Now, here's another thing y'all need to know while you're reading your Constitution. Please go to the Code of Georgia 16-1-3, subparagraph 13. And that gives you the definition of property, which is anything of value tangible or intangible.
Judge, I'm sorry, excuse me. Could you give us that code again, please?
Yes, 16-1-3, subparagraph 13.
Thank you.
Yes, ma'am. It is imperative that you understand, and to go back to Article 1, Section 1 for just a minute. In there is a list of privileges and immunities that belongs to all of us collectively. But it is also your individual property interest. You have a property right to that, to each of those. And it shall not be deprived without due process of law. You might also like to know, now that we're talking about the state's abuse of sovereign immunity claims and judges allowing them to do it, you might also like to know that that provision in the Magna Carta, that waiver of sovereign immunity, did not exist in the U.S. Constitution until the 14th Amendment. And now we find that all 50 states, all of our insular possessions, have waived their sovereign immunity in the 14th Amendment, Section 1, Clause 2. No state shall enforce. Actually, it says, no state shall make or enforce any law, criminal or civil, it doesn't matter. No law shall be made or enforced which abridges the privileges and immunities of a citizen of the United States. That's another thing you'll find in this Constitution is your citizenship. And you will find that not only are you a Georgia citizen, but you enjoy dual citizenship with the United States of America. It's another contracting entity. So please know that you don't need to worry so much about the clothes on your back or the house you're in or the car you're driving. What you really need to be concerned with is found in Article 1, Section 1 of the Georgia Constitution.
So Judge Nally,
Yeah,
a quick question regarding that dual citizenship and the clause there. In relation back to them signing treaties like with the World Health Organization or any entity outside of the United States, where we are giving up our rights as citizens underneath of a treaty signed on behalf of us by our federal government.
are you asking if we are giving up?
Well, what I'm saying is based on the Constitution, we could fight that, correct? Even though
Well, okay, if a treaty is actually entered into, yes, the treaty becomes the supreme law of the land. However, you have remedies to prevent your Congress from enacting such treaties. And you can do that with petitions for declaratory judgment, petitions for injunctive relief. And you also, oh, Lord have mercy. I'm sorry, folks. I overlooked I overlooked the most important provision of Article 1, Section 1. We'll have to get back to that immediately. But you have another avenue of remedy, and that is with your grand jury. Now, I know you don't, most of you are familiar with declaratory relief and injunctive relief. You're familiar with your methods of suing some entity for some reason, and that would include suing the government. You have a basic understanding of how these things are done. But what a lot of you don't have is a good understanding of the remedy that is available to you, a legal remedy available to you in Article 1, Section 1, Paragraph 11. And if y'all want to go back and look at that, I think it would be beneficial. I'm trying to see if I can get back to it myself.
Judge, was that question in reference to the WHO treaty? I missed the first part of her
Yes.
question.
Yes.
Yeah.
Yeah, we need to get out of that.
Well,
Thank you.
Well, now you have to excuse me, because every once in a while, I'm going to have to give credit where credit's due. Some of you are going to catch me a little short. I don't know that is a treaty. I have not seen it. I've not had an opportunity to read anything that tells me that there is a treaty with the World Health Organization. I can't imagine that there would be.
Yeah, that's what they're calling it. And I had a copy of it. I'll find another copy and I'll send it to you.
Okay, now let me ask, since you've got a copy, let me ask you this question. Is there a piece of legislation passed by the Congress calling that document a treaty?
That's what I need to look for.
There you go. That's important. I don't care what they call it.
Right.
I care deeply about what Congress did with it.
Yep. Okay.
I'm not sure Congress has done anything with it yet. I know there are some that are fighting it, but James Roguski from Substack does a lot of reporting on this. And I'm sorry, I didn't see who's speaking, but I have a lot of information from him. I know that they're using a very key word. I heard it called a treaty, but then I've heard it called it something else that would not allow us to get out of it.
Right. There's a couple of things there that they're trying to make it so that we, quote, can't leave it, and no matter when. Or
oh, well, now wait just a minute. I mean, excuse me for interrupting, but that's probably a good reason right there for every one of you to go read Article 1, Section 1, Paragraph 11 of the Georgia Constitution.
Yes. And that's what I was trying to come back to with that question was, can we institute that piece of the Georgia Constitution and start with that as our grounds for anything really with what they're doing?
Okay.
So federal.
Let's when you get a chance, I want you to look at Paragraph 11, subparagraph B, and you can skip the first half of that sentence. Wait a minute.
What article are you looking at?
Article 1, Section 1, and it's supposed to be Paragraph 11. I'm sorry, it's Paragraph A. Just ignore that first sentence in Paragraph A. Go to the second sentence where it says in criminal cases. In criminal cases, the defendant shall have a public and speedy trial by an impartial jury. Then there's a semicolon. Now that semicolon is important. That's another thing you've got to watch for in the language, the written language of your laws and your constitutional provisions. Watch that punctuation. But anyway, there's a semicolon. And then it goes on and it says, and the jury shall be the judges of the law and the facts. Every one of you need to take a few minutes and think about the scope of 23 of your neighbors judging every law on the books. I mean, every law. And here's where I need to stop and explain something to you about this. In a criminal trial or a civil trial, now here the Constitution says in criminal trials, what you need, I'm sorry, in criminal cases, what you need to understand is this statement is being explicitly attached to criminal cases. However, the common law, under early American common law, now I'm not talking about English common law, under early American common law, civil juries were also recognized. As a matter of fact, our first Chief Justice, John Jay, in his charge to a grand jury, made the statement that he understood they were judges of both the facts and the law. That's written. That's in black and white. And that hasn't changed. In spite of the fact that judges do not want you, if you're a juror, every lawyer that practices in front of you knows good and well he will never let those words slip past his lips. You will never hear a lawyer say, you are the judges of the law and the facts. That'll get him a contempt citation in a heartbeat. And the reason for it is judges do not want you to understand the full scope of judging the law. But in this particular case, you've got to understand that semicolon is referring, whatever follows that semicolon is referring back to criminal cases. And in every criminal case, there are two juries. There is a grand jury in this state, and there is a trial jury. Here's where you need to understand the distinction between the two. Both of them judge the law. In a trial jury situation, a judge in a criminal trial, when it comes time to for him to charge the jury, he will give you the law of that case. Or maybe it's 2 or 3 statutes that's been violated, but he'll give you each one of them. Those are the laws you will judge first. That's the first thing you do when you go in that jury room, or you should do it as a juror. You should judge the laws. Is it a good law? Is it a bad law? Is it a good law, but it may violate the Constitution? Those are the questions you have to ask and answer as a juror. Now, if it's good law, now you turn your attention to the facts. Do the facts address the elements of the crimes that have been charged? And if they do, then you have a choice. You can indict, you can present, you can find guilty, if you're a trial jury, even, well, I'm about to get ahead of myself, so let me back up. Now let's go to the grand jury. The grand jury is the conscience of the community. And not only does it judge the laws first of the criminal cases that are being presented to them by the district attorney or by someone else, but they also get to judge all other statutes on the books. So if you have a problem with a particular statute and you get sworn in as a grand juror, then you're going to be able to bring up your concerns with your fellow jurors. And that, ladies and gentlemen, is where a claim that there is a treaty between the United States and the World Health Organization, that's where that question needs to be, is with a grand jury. Because I'm betting you a grand jury is going to come back and say, wait a minute, no, that ain't going to happen. There is no such thing as a treaty between the nation of the United States of America and a corporate functionary of the United Nations. Now, there can be a treaty between Great Britain and the United States. There can be a treaty between Taiwan and the United States. There can be a treaty between Australia and the United States. But a treaty with a mere functionary?
Judge, I think where it gets technical is when they suspend the Constitution for health emergency powers like Kemp did in Georgia.
Well, whoa.
That's the scary part.
Yes, it can be scary. And that's where the grand jury needs to remember what, please remember what Teddy Roosevelt, he was fond of using a phrase, an African saying, walk soft and carry a big stick, you will go far. Well, ladies and gentlemen, your grand jury in Article 1, Section 1, Paragraph 11 of your Constitution is the biggest stick in this nation. And it's in your hands. That is the big stick. Now, do the grand jurors today know and understand the full scope of their power? Of course they don't. They're your neighbors. Most of them are good folks. Virtually every one of them is dumber than dirt. And that's okay. You don't need intellectually competent individuals to sit on juries. You just need folks that's got good common ordinary sense. Common sense. They need to be able to look at a set of facts and say, yeah, I believe that set of facts, and no, I don't believe that set of facts. And all of these that I do believe put together, and yeah, that convinces me that there's a true bill needed here, or they don't convince me that there's the necessity of a true bill. So I'm going to vote to no bill this. They just need common sense. But they need someone, ordinarily it would be a district attorney, if it weren't for the fact that your district attorneys are political creatures and they don't need to be carrying the constitutional and statutory authority they have to be advisors to a grand jury. That's something that we need to consider changing in this state. We need to get rid of district attorneys as advisors to the grand jury and do like the state of Hawaii. Make it a constitutional provision that there will be an independent attorney hired to be an advisor, and those attorneys will change periodically. I don't mean leave one person, one attorney advising every grand jury. No. But as many attorneys as there are in this state, there is no reason why that each local county bar can't put up 3 or 4 candidates during the course of a year so that each grand jury can have a selection from legal advisors for any question they might have. But anyway, that's something for the future to think about. But it's imperative for you to understand, if you get a summons to be an appear at the local courthouse to be selected as a grand juror, that's something you need to run down to the courthouse to do. Anytime you're summoned to be a juror, you should be willing, ready, and able to go exercise your common sense. That's what it's going to take. But you also need to know the scope of your authority, especially if you're a grand juror. And that's important because the grand jury is at all times the conscience of its community. Now, I've probably been running off a little too much here for you, and well, that's okay, not a problem. I think we can take up here next Sunday, I guess, if anybody wants to come back.
Yeah, excuse me, Judge, and that's what I wanted to bring up to the group, since next week is July 4th weekend.
Okay, we can skip that one.
Skip one, yeah.
Yeah. Okay, we'll skip next week. Yeah, all of you can go party.
Mhm.
All right, so we can
All
do
right.
that.
All right, so I'll stop the recording and I will send out an email to everybody about where we end up putting it up.
Okey-doke.